We are here, well, first, good morning, everybody. We're here for the initial hearing of the Utah Utility Facility Review Board. Just by way of introduction, this board does not meet very often, but the board is consisted of the three members of the Public Service Commission, which is myself, Mr. David Clark, and Jordan White at the end. It has two additional members. Beth Holbrook is a board member from the Utah League of Cities and Towns. You're on the Bountiful City Council, is that right?
That's correct.
And then a fifth board member was appointed 2 days ago and is not able to be here today. David Wilson from the Weber County Attorney's Office is a fifth board member, and he's given us dates that he is or isn't available for hearings, so we should be able to work out the scheduling issues that way today. And just as an announcement, I just want to let everybody in the room know, this is an odd announcement, but we were informed yesterday that the Utah Highway Patrol is doing active shooter training in the building today and tomorrow, so there may be noise from that. It's something that's being conducted by Highway Patrol, so if there's noises, that's what's going on. Why don't we go to appearances next then? Those who are here to make an appearance, we'll start with the applicant.
Matt Moskin and Heidi Gordon for Rocky Mountain Power.
Okay, thank you.
Tyler Berg with Wasatch County.
Jeremy Reitzel on behalf of the party seeking to intervene, Black Rock Ridge Homeowners Association and Mark 25.
Okay, thank you. We have a few issues to go through in this hearing, in this initial hearing today. So the first issue is whether this will be a formal versus informal proceeding. We've received a few comments from parties recommending that it be a formal proceeding. To my knowledge, we have not received any request for it to be an informal proceeding. Do any of the parties in the room wish to address that issue before we take that issue under advisement? Well, starting with the applicant.
No, in fact, thank you, Mr. Commissioner. We spoke again before the commencement. I think all the parties agree that formal makes the most sense.
Okay. For the
For
county?
Wasatch County as well.
Okay, and Black Rock have any different feelings on that?
No, you're
Okay. This, for those who are used to participating with the Public Service Commission here, this board acts a little bit differently, so I think we have to do public votes as a board on any issue that we deliberate or decide. So I'll come back to the board. Is there any discussion of the issue of whether this should be a formal or an informal proceeding? I guess I'll just start with Mr. White.
Yeah, based upon the consensus of the parties, I think it's appropriate to proceed forward as a formal proceeding.
Any other comments? Guess I'll entertain a motion.
So moved.
Second.
Okay. Yeah. All in favor of proceeding as a formal adjudication under UAPA, say yes or aye.
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 Any opposed? Okay, that seems to be unanimous. The next item of business is a hearing date. So under statute, with today as the initial hearing, the last day that this hearing could be held is May 20th. Just to let everybody in the room know a few issues. There are Public Service Commission hearings the 17th, 18th, 19th, and 20th of May in a matter involving the Navajo Tribal Utility Authority. So those are not available as hearing dates. We've heard back from Mr. Wilson, who is the fifth board member, who is unavailable due to a family event out of state, May 12th through the 17th. So those are dates that are off the table, and I think maybe well, let me ask you, if in the weeks before May 20th, are there dates that you are and are not available?
So I will be in St. George in April for the Utah Lakes Conference, and that's the April 4th through the 9th.
Okay.
And I do have a little bit of traveling for my company, so 13th and 14th I'm gone as well in April. But,
Of April?
May is fine. I don't have any issues with May.
Okay. Let me go to the parties then, and just get a sense for what you're thinking in terms of how long of a hearing, how much time we need to reserve for hearing in this matter. I'll start with the applicant.
Sure, and if it helps, I'll also represent, this is something that prior to the hearing, we discuss possible dates, recognizing it may or may not work for the board. I think that we agree that this is a one-day hearing. I recognize the board may want to include or add at a separate time a public comment period, and that may be at the same day, but I don't think any of the parties believe that we need more than one day to hear the issues regarding the company's position.
The county agrees with that, and we also discussed possible dates. And I think we had an agreement based on what would work with the board, that May 11th would work for the parties involved, so that would be the day before. I guess you'd said the 12th through the 17th, and then the 17th through the 20th were all blocked out.
Right.
So the 11th, that Wednesday, I believe, would work for the parties.
Okay, and everyone's in agreement on the May 11th date? Any
Yes.
concerns from any of the board members? Okay.
I guess my only concern would be if, for some reason, one day is not adequate, we don't really have options
That does,
beyond that point. So just so the parties understand that we would be
We-
absolutely constrained to.
I guess maybe if we wanted to say, just for sake of that purpose, if we wanted to say May 10th, which is what Rocky Mountain Power had originally proposed, if we just said we start the hearing on May 10th and just reserve the 11th as a possible day, but we think that we should be able to complete it in one day, but having that safety net's a good idea.
okay, any objection to that from any parties?
No, we agree.
Any objection to that from any board members? Okay, I don't think that's the kind of issue that requires a board motion, so we will probably have a board motion on all the dates for getting a scheduling order out, but we'll set May 10th and 11th as the hearing date. Then next, let me ask the parties their thoughts on time and/or place for a public witness hearing. First with the applicant.
This is, I have to concede, an area we haven't really discussed. The company recognizes that it's probably appropriate to have the ability of members of the public to address the board. So should there be one, we absolutely think, yes, there should be. We haven't addressed actually the location or time or place. In my mind, I was thinking it would be kind of a continuation of our hearing or proceeding, but I have to admit that's not anything that we specifically addressed. But I don't know that the company feels strongly, if the board thinks it's better to do that up in Wasatch County. I can see why you would want to do that. We just have to find a different date and time that we could do that.
Okay. And of course, the public witness hearing doesn't necessarily have to be right around the same time as the substantive hearing either.
Agreed.
So I'll move to, Wasatch County, have any thoughts or comments?
I think it would work best just for county residents, if there are any that want to come and want to be to that public hearing, that it would be located in Wasatch County. If we were to do that after May 20th, that would be outside the 60 days, but I think the statute would allow for that. That would allow the parties to have their formal hearing on the 10th and possibly the 11th, and then allow the board the time to meet with the public at the public hearing. So,
Or what about thoughts of having the public witness hearing prior to the substantive hearing? Is that?
I don't have any objection to doing that at all. I don't know that there's an issue with that. I haven't considered that. I think that would be something I'd need to talk with our county council about, scheduling wise, as to where a location, as well as making sure we had notice out to the public, but that's something we could definitely do.
Okay. Well, let me go to Black Rock, where not yet an intervened party, not a party at this point. That's still an issue to deal with, but I still think I'll get your input on this issue.
Yeah, we obviously think that public comment's appropriate. We don't have a real opinion on when it should be, other than I think it should be sometime after the company has produced their documents and their testimony, so that those things can be addressed by the public as well.
Let me go to the utility. Any concerns with it if there's a public witness hearing in county facilities in Wasatch County?
No, I don't think we have an objection if the hearing is in Wasatch County or in county facilities. I think we would, and also we don't have any objection if the public hearing is after parties file memos, pre-file testimony, anything like that. I think it would be appropriate to have the public comment at same time or prior to the formal hearing of this body, because if members of the public were to raise questions that actually gave any of the board members questions, I would like my witnesses to be able to answer and address those. And if it's held afterwards, I would hate to have there be a question in your mind that wasn't addressed. So I would suggest that it be prior to May 10th.
Well, should we talk about May 9th as a potential public witness hearing in Wasatch County? Or were you indicating that you needed to maybe touch bases with others in the county if county facilities were going to be used for that?
I would like to find out, and I think it's far enough in advance, I don't know that the 9th would be an issue, but if I could at least have a few days to confirm with the county council and make sure that location of where they would want to do that at, timing, I don't have a schedule of all the different possible buildings that we could have it in or what might be already taking place at those locations. But I would think the 9th as a preliminary date would work. I could get back to all parties if that date wouldn't work.
Okay, and one option for timing, let's to throw that out, is starting a public witness hearing at 5 p.m. with the condition that we'll hear public comments from anyone who's present by 5:30 or so. Does that sound like a reasonable time frame to any parties?
Well, I
in the
know
room?
with, at least with the planning commission and as well as the board of adjustments that have already taken place, at least the public comment, the planning commission went, I'd say at least an hour, and that was with the director of the commission cutting people off and keeping it short, and stopping people from repeating, so I would think we'd probably need more than a half-hour amount of time.
I was just indicating, saying, anybody who's there by 5:30
by
will stay long
5:30,
enough to
stay
let the
longer.
people that are
Okay.
there by that time to speak.
Okay,
So not cutting off the hearing then, but.
okay.
The only, and I don't mean to interrupt, but the only thing I'm just thinking is if we have an evening hearing, which I understand makes sense so that people can go to their day jobs and then participate, and if that's up in Wasatch County, and then if we are starting early the next morning for the formal hearing, I'm just noting you'll have people up there until midnight the night before, and then starting down here 8 hours later. I wonder if it might be worth considering having the public comment on the Thursday or Friday, right on the other side of the weekend, just to avoid that. I'm not demanding it, I'm just thinking out loud.
No, that's a really good suggestion, and I think it makes sense, considering we don't know how late that hearing will go. Well, should we look at days the previous week then? Looking at some travel for some board members, it looks like Monday, May 2nd could be a possibility. I'm not sure if Thursday, May 5th is might or might not be, but Friday, May 6th could be also. Is there a preference between those three dates? Let me go to the board members first. If we were looking at either the May 2nd, 5th, or 6th for a public witness hearing?
From my perspective, the 6th would be preferable. I'll be at a NERC Board of Trustees meeting on the
Looks like third,
well,
fourth,
on the
fifth.
4th and 5th, and the meeting will end at noon, but I'll be in Chicago. So, at noon on the 5th, so it would be, either I would have to leave that board meeting early, which is, it's conceivable I could do that, or do it on the 6th. So I'm just going to express a preference for the 6th, but if people have unavailability on that date, the 5th would work.
Thoughts from?
It's 6th, and you're saying that the Monday the 2nd, that you'll be traveling?
No, Monday 2nd is a possibility also from at least our schedule, not, I haven't talked to them yet. but
I could do either.
2nd or the 6th.
Same, I could do
Same?
either,
Okay.
2nd or the 6th.
Any preference between those two options, or are they both good options?
As far as I can tell, they're both good options. I'll just need to, again, be able to check and make sure that we have a location and make sure that that will work, so.
Okay.
If Commissioner Clark is available on the 2nd, I think the company would prefer the 2nd over the 6th, but we'll make either day work. If he's traveling on the 2nd, then we would make the 6th work.
I'm
Okay.
fine on the 2nd.
That'd be our preference of those 2 days.
Okay, well, why don't we pencil this down for the 2nd? We would probably have to issue an amended scheduling order once we have the location, but we'll plan for 5 PM on May 2nd. Next issue to discuss is, well, I think I'll come back to that one. Let's talk about an intervention deadline. What would be, with a hearing on May 10th or 11th, are there thoughts from parties on what would be a good deadline for any petition to intervene? Now, let me start with the applicant.
So I assume the board recognizes the company's position that the only other party that would have standing to intervene would be Promontory. But without addressing that, I suppose any decision to intervene needs to be made relatively promptly, just because this is such an abbreviated schedule. We had, between the parties, discussed some timing of filing papers between us that we would propose to the board. The first of those dates is April 8th, and the board may or may not accept that, but I guess what I would say is whoever is or is not going to be a party probably ought to be in the case before papers start being filed officially. So if that helps as far as scheduling a time, we had the 8th as being the first due date for filings in our schedule that we were going to kind of jointly propose to the board.
And so you're suggesting an intervention deadline prior to April 8th?
Yes.
Like,
Let's see here. So I would say April, a petition to, how about if there's a, if anyone wants to move to intervene by April 4th, and I don't know how long the board needs to make a decision, I think we would just say we're going to be, our proposal to the board will be that papers start being filed on April 8th. So that week, whenever that week of April 4th, I guess, is what I'd propose. Any other thoughts?
okay. And I'll just mention, I was going to mention this in context of another issue. One difference between this board and the Public Service Commission is, for example, making a decision on a petition to intervene has to be done by this board in a public deliberation meeting. So once petitions come in, this board will have to meet and make a decision on whether to grant intervention. Board members who aren't Public Service Commission employees obviously could participate by telephone if that were more convenient. Telephonic participation is appropriate, but I just want to make sure everybody's aware of that's part of the process that'll have to happen post intervention petition. So April 4th, still considering that, does that make sense from your point of view?
If the board would be able to, by telephone or otherwise, meet sometime between the 4th and the 8th, then that seems to work for me.
Let me go to Wasatch County. Any thoughts on that?
I think that would work fine. My thought on it is that the parties who would be intervening have already filed their petition. There's always a possibility someone else might file a
Okay.
petition, but given the location of where the transmission line would go,
Sure.
I'm not sure who else, other than Promontory, would be able to even claim any right to intervention. And so I would think that deadline of the 4th would be more than sufficient.
Okay. Any thoughts from board members on that? We could pencil that down for now. I think we probably need a motion at the end of the hearing with all the dates for a scheduling order, but pencil that down. Any objections? No? Okay. The other thing that needs to be on the schedule towards the end is a final deliberation meeting post-hearing for the board members to deliberate after the hearing on the 10th and the 11th. And it seems to me to make sense to you, since we're reserving 2 days, parties are thinking it's probably a one-day hearing. I'm thinking through this issue as I'm speaking. We probably should plan to use sometime on the 11th for board deliberation. We could schedule that for the afternoon of the 11th, assuming that if the hearing runs late on the 11th, we could just push it back. If the hearing finishes on the 10th, we would just know that we're going to reconvene the afternoon of the 11th to deliberate. Let me just go to board. I think this is an issue just for board members, but it's noticing up a deliberation meeting the afternoon of the 11th with the understanding that it might get pushed back if the hearing's still going on. Is that acceptable reasonable to the three of you?
I just had a question, pushed back as in the same day and pushed at a later time, or pushed back at a totally different day? What do you?
I'm thinking worst-case scenario is if we noticed it for, early afternoon on the 11th, there's some chance the hearing's still going on. I think we've heard from the parties that that's not likely. So if we schedule it for afternoon of the 11th, we'll probably start on time, but there's a chance we would have to just push it later into the afternoon rather than starting it. If we noticed it for 1 PM, there's a possibility we might have to start later.
So are you suggesting that it would be noticed after either the conclusion of the actual hearing, or, in other words, there'd be some fluid nature to the date, in other words, we could move it back or forward?
Well, that's what I'm not, I was thinking we would just schedule it for a definite time. So if the hearing concluded on the 10th, we would simply plan to come back on the 11th to deliberate.
Yeah, I like that because it will give us some time to digest what we received during the hearing as well. Likely will give us time, and that would be useful to me.
And, what this board will have to do is discuss what's in front of us, make a preliminary decision directing the drafting of an order, and then some process after that to issue the order. The order issuing deadline is June 6th, I believe, so we have between the hearing on the 10th, the 11th, and the 6th to do that. But for an initial deliberation meeting, does that work for you?
Mm-hmm, that would work.
Okay. Well, why don't we pencil that for 1 PM on May the 11th? Okay. A couple other issues. Motion deadline. Go to the applicant. Any suggestions for a motion deadline?
No, other than, one of the things that we had anticipated, and it was referenced in the company's petition, is the company does anticipate filing a legal memorandum, kind of setting forth its case with, and this is again an issue to be addressed by the board, but assuming the board agrees, pre-file testimony on April 8th. So to the extent that that's considered a motion, I guess I'll note that for you. I don't anticipate that there being a lot of other motions being filed by the parties. So to be candid, I don't know that we really have decided or discussed motion deadlines between us. And as I sit here, I'm trying to consider what motions. I mean, I suppose there could be some dispute that comes up along the way, but I don't anticipate there being a lot of motions in this matter.
Okay, well, why don't we just kind of look at all the dates then? I don't know if parties have talked about, you mentioned written testimony filed in advance, or whether that's going to be done in this case, or whether it'll simply be replies and responses.
Sure.
Has there been discussion about what would be filed between now and the hearing? Let me go to the county.
We discussed, as Rocky Mountain Power was indicating, filing of memorandums, legal information and everything that way. We discussed April 8th as the deadline for Rocky Mountain Power to file their memorandum and any accompanying documents. Then we discussed April 22nd for Wasatch County, as well as Black Rock Ridge, if they're allowed to intervene, for that to be their filing deadline for memorandum. And then also April 29th as a reply deadline for Rocky Mountain to be able to reply to any issues brought up. I can't, again, as Rocky Mountain indicated, I don't see this as being a lot of motions. I know that I'll have a discovery motion for them later this afternoon. Aside from any motions to compel or any discovery issues, I don't really see any other motions glaring out at me right now. But I also don't know all the legal issues that they're going to file in their memorandum on the 8th. I would think maybe if the hearing is going to be the 10th and the 11th, if we said that we had a motion cutoff date, maybe that week prior, the 3rd, May 3rd, that would allow at least a few days after they'd filed their reply memorandum for parties to get any additional motions in that we may feel we needed to have addressed. And I would assume that we would probably just address those motions at the hearing on the 10th. I wouldn't see a real need to intervene, but then again, we don't know exactly if there will even be any motions. We don't anticipate any, but if there are, is that something that we would need to hold a public hearing on with this board to address any motions?
Well, I would think if any motion that's filed in the neighborhood of May 3rd, the earliest it could be ruled on would be the first day of the hearing,
Okay.
on the 10th. And then we'd have to work out what we needed from parties before ruling on that. So I guess I'm hearing a proposal for legal briefing or comments from Rocky Mountain Power on April 8th, legal briefing and/or comments, legal briefing and/or comments from Wasatch or any other intervener April 22nd, replies from Rocky Mountain Power on April 29th, and a motion deadline that hadn't been previously discussed of possibly May 3rd. Mr. Moskin, is,
A couple of quick things. I had in my notes that the company is going to file its rebuttal on May 2nd rather than the 29th, and I'd have to open my calendar to see even what day of the week that was, but that's, I don't know if that matters, but
I apologize, I might have written that down
That-
wrong as we were talking. The second is a Monday, the third would be the Tuesday. And I would have no objection to having them have that weekend to do a reply. So if we did May 2nd for their reply, and then we even just moved the motion out, I think if we even moved the motion out till the 5th, Thursday, or the 6th, then if it's something we're going to address at the hearing, that would be adequate time to do that.
yeah, I don't think the company has a lot of concern about a motion deadline being late in the process, candidly, just because I don't anticipate there being a lot of motions. As I would agree, as was indicated, it's possible someone may, along the way, think there's some discovery issue or something, but in any event, I don't know that there's going to be real substantive motions that are going to be filed, and by that time, we're kind of past everything's been filed, so I don't think that you're going to be having discovery issues coming up post May 3rd in any event. One thing that I will note, I think it is the company's preference, and I realize it's not a requirement, meaning the board has not formally adopted this, but I think the company would propose for the board to consider that to the extent that any of the parties are going to offer affirmative witness testimony, that the parties file pre-filed testimony in the same time frame when we said legal memoranda or other papers or arguments. And I'll explain why. Those of you that are members of the commission will recognize that some of the information, data that the company relies upon is relatively dense, and it may not be something that you want to hear someone go through on the stand, but is necessary as part of the record. One of the things that my client needs to do in this case is to demonstrate a need, that we need this. And someone can just say that in the thing and have a bunch of exhibits, but to put that through live testimony may be a burden that no one wants to go through. So that's just one example of why I think it would make sense to have pre-filed testimony. I think that just because of the condensed time frame and the limited discovery, I'm not saying there won't be any discovery, but the relatively limited ability of the parties to get discovery from each other means that we probably ought to know what each other is going to say before we show up to the hearing on the 10th. I also think that if we did that, it would be more conducive to having everything done in one day rather than people are trying to do quasi-discovery, what do you really mean, questions and cross-examinations if there hasn't been pre-filed testimony. So the company would propose, and I believe that if I'm not mistaken, this has been the practice of the Facility Review Board, the only other times I'm aware of it convening, that affirmative testimony be by pre-filed testimony.
let me go to the county.
At this point, I don't know exactly what type of testimony we would have until I've seen their legal briefing, exactly what they'll be arguing on it. And so, I don't know that I can stipulate to say, yes, we could have everything by April 27th, our deadline for all of our briefing to be filed, but
Let me
we
just
would make our
clarify.
best.
I thought I'd heard you say before April 22nd. Is it 22nd or 7th that we were looking at for your deadline?
I thought we had April 22nd.
22nd?
Is that
2-2?
right? Yeah.
Okay, yeah, that's what I
2-2.
have. That's what I have. Okay.
We would obviously make our best efforts to do that, but at this point, I don't know exactly what pre-file testimony we might have. And I think the 2 weeks that we would have to do our reply, we could probably discover a lot of that. Anything that we know ahead of time would be able to do. I don't know if we could say we could have all of our briefing done on the 22nd and then have an extension up until, another week or two to have any pre-filed testimony that we're just finding out that we're going to do at that point. I don't know that, well, we wouldn't be trying to hide the ball. If we have pre-filed testimony, I agree with Rocky Mountain Power that we want to get that in front of the board as quickly as possible. We want to make that hearing truly just a one-day hearing. No, there's no reason to call a whole bunch of witnesses that we can already have all their information on the record.
And let me clarify too, what I mean by pre-file testimony of affirmative witnesses. I don't want the county or any members of the board to think that the company is suggesting that literally any word spoken will already be in writing. So I believe that Wasatch County, for instance, should be able to cross-examine any of my witnesses live in the courtroom if they want to say, is this what you mean and didn't you mean that? And let me show you a document, and isn't it true this says that? So there would still be that opportunity. I'm only talking about affirmative statements. So for instance, if Wasatch County, and they haven't said they were going to do this, but if they were going to say, we've hired an expert that believes you don't really need this transmission line, there's no need to get more power and bring it out of Wyoming down into this territory. If this is going to be a meaningful hearing for the board, and I don't know that until here we are on, May 10th, I'm not going to be in a position to rebut that because this is the first time we're hearing it. And so if there's going to be an affirmative position taken like that, because of the complexity of kind of the utility process, that I think just needs to be put in pre-filed testimony with any kind of questioning reserved for the hearing. I just don't know how to do it any other way in such a consolidated manner.
And it does seem that, at least in practice at the Public Service Commission, filing of written testimony in advance has streamlined both discovery and hearings. The question I think we have for the board from what's been presented is whether that becomes a mandatory part of this scheduling order, or whether we go with these dates and say parties will file any legal briefing, any comments, and if they're going to file any testimony in advance of hearing, those are the dates they file them by. Whether it's mandatory or allowed. So that's an issue for the board to discuss, but let me, any further comments? I think you both kind of.
I would think if we were to do something where it's allowed, but not mandatory, that would work for the county. We would absolutely make any effort to get Rocky Mountain Power all the information that we're looking at. We agree that we want this to be a streamlined process and as straightforward as possible. It's not going to be a hide the ball and, day of the hearing, we've got this expert witness that we're bringing forward. That's not what the county's anticipating at all. But we would appreciate it if it was something that was not mandatory, but something that was allowed to happen. We would make every effort to have that happen.
Okay. Any further comments?
The only thing, when I'm just thinking through the practicality of how such a rule would work, is if I don't know whether or not they are going to, in my example, have someone show up on the day of the hearing and say, I'm a utility engineer expert and they don't need this, that makes me almost tomorrow in day one send out a bunch of contention, interrogatory, I need to know that, and I can't just go, well, they used their best efforts, I guess they couldn't get it in time, but now I don't know. And so that's why in our motion, we tried to limit it to affirmative positions. So if you don't have to tell me in advance every cross-examination question or what you're going to say in your legal briefing, but if you're going to take an affirmative position as to any of the issues of, reliability, safety, need, efficiency, the kind of the benchmarks that the board's deciding, I still think that has to be mandatory if they're going to have a witness that they want to present testimony to the board on that topic. If they don't want to bring a witness and they just want to make legal arguments, obviously they don't need a witness to say everything that they can put in their legal briefs. But I think that in this tight 60-day time frame that we have, and without an ability to depose people and do all this kind of contention interrogatory thing, I really think it has to be, or I'd suggest or move that it be a mandatory rule for any affirmative witnesses to file pre-filed testimony so that the hearing can function on the 10th and 11th as the parties, I think, all envision.
So your motion would be that on these deadlines, any fact witness that a party intends to use at the hearing would have to have filed written testimony on these dates. I think you're making a motion to that effect.
Correct. That a party can still file a legal brief without a witness, but if they want to put a witness on the stand on the date of the hearing, that they need to pre-file that person's testimony in accordance with the deadlines that we've laid out. That is the company's motion.
Okay. Just any final comment? I know we're doing a lot of back and forth, but I think before the board discusses this, anything else you'd want to add?
Can I make a
We go to
comment?
Black Rock and then, yeah, and then Wasatch.
Generally, I don't have an objection to that. I see one of the problems being the company has a lot of experts at its disposal, and it's going to be disclosing this information, in April, and then there'll be several weeks for us to respond. We don't know what we're going to need to respond with, and my experience in trying to get experts is you can't get them to drop everything in 2 weeks and get something on file. Now, that's certainly something, if we're allowed to intervene, we'll try to do. But I wonder if we could leave that date a little bit flexible in that you either file pre-file testimony or you file a motion with the board explaining why you need a few more days to get the pre-filed testimony in place. Because it is complex issues and it's something that the attorneys can't put together themselves. We're going to need some expert testimony, I expect.
Okay, any other additional thoughts from Wasatch?
I would agree with that. I can understand Rocky Mountain's position of why they need that information, just like we need that information from them. They need that from us to be able to do this in 60 days. Actually less than that, since we're moving the date back almost 10 days, so about 50 days. But again, until we've really seen what they're filing, it's hard to say, yeah, we can absolutely have it by that date. Even if we were to say, well, if we were to do our pre-filed, if we could look at it and say, here's our legal brief, can we have an extra week to get the pre-filed in? So maybe just by motion is the best way to be able to ask the board, hey, here's everything. We're anticipating this additional witness, but we can't get the information from them until this date. This is what we think we're going to do with them. Maybe like even a summary of this is a quick one-paragraph summary, but to get more of a written testimony. And again, I'm thinking worst-case scenario. Do I think that's going to happen? I really don't even know that in this case that's going to happen at all. But I'm just not wanting to get locked into a deadline that I don't know if I can meet until I've gotten the information from them.
And I'll just note, just looking at the schedule, we are talking about between, we have Rocky Mountain Power's initial deadline is April 8th. The other party's deadline would be April 22nd, and between that and the final deadline of May 2nd, we have a week and a Monday. So there isn't a lot of wiggle room between that second and third dates. I'm just noting, but maybe it's time for board discussion on it.
Yeah, can I maybe start with Chair with maybe a comment, maybe a suggestion? I'm taking off my PSC commissioner hat right now and acting as a member of this board. I mean, we're very comfortable with this type of process. It is through the 100 years of our history of the PSC been efficient and in terms of moving and evaluating large amounts of complex evidence. But I guess my concern as a board member is, obviously this is probably not your world, and you're probably not used to in typical legal settings dealing with what we term as pre-filed written testimony, et cetera. I guess what I'm wondering is, does it make sense at all, for even a potential brief recess to maybe help walk them through that and help them understand how that might work? Because I kind of get the sense there may be some kind of disconnect of what this would actually look like. And again, I don't want to, maybe you understand this perfectly well, but if that's the case, and that would be helpful to the parties to maybe discuss that, because I do agree that, because we have such a tight statutory deadline, and we're not going to have a lot of time for a lot of motion practice or et cetera, and we want to make sure it's as efficient as possible. I would prefer this, but with that being said, obviously I want to make sure that the typical non-PSC parties are comfortable with this, so I don't know if that makes sense to, have that type of discussion off record for a few minutes or not. Maybe that's not an option, but.
you parties feel like that would be helpful, or do you feel like you kind of understand where
More than willing to
Yeah, we're willing
discuss
to
what we're,
discuss with it as well.
we're
Even for a
talking
few
about.
minutes, we can kind of go
should
through
we just
it.
go off the record for just a couple of minutes?
Let me just lay out then the remaining issues before we do that we have to. We still have an intervention petition, and maybe while you're discussing this, I just want to lay out our options for how this board deals with that intervention petition. I mean, one option is to take oral argument today and have a board deliberation today on the petition to intervene. Another argument is obviously BlackRock has not had a chance to reply in writing to Rocky Mountain Power's opposition to your motion to intervene. So another option is to let that play out, but then this board comes back together again at some point farther along in the process. And obviously, again, we're talking about a tight time frame. So I think those are our two options to deal with that petition to intervene. I just wanted to mention that as the options, maybe as if we're going to recess for a few minutes. And I think that's basically the remaining business we have to deal with. Anything else that we need to talk about before, if we recess for a few minutes? We're thinking 5 or 10 minutes?
Can I just,
Sure.
if I could just address the pre-filed testimony question for a moment, so that you'll have my thoughts as you work through this. First, personally, I think it will be very helpful, particularly given the tight timeframes we're dealing with. Second, again, those timeframes I think are uncomfortable for all of us, certainly for this board, and I'm sensing you're feeling them too, and are wanting some wiggle room if something happens that you don't anticipate. And I think that's understandable. But would be helpful, I think, to at least have some dates that are reasonably firm, and dates with regard to which we would expect the parties to be thinking in advance, be planning in advance, be making reasonable judgments about what their opponent is likely to say or do, at least. And then if there is some real surprise, that personally I would consider a motion at that time to alter the schedule if we need to, within the constraints that are set out in the statute. So those are my thoughts on the matter.
Any other thoughts before we take a 10-minute recess? Did you have anything to add? Okay, why don't we recess for 10 minutes? Is that good? Okay. Come back at 9:55 by that clock. Yes. back on?
Yes.
Okay, we're back on the record. Let me just go to the parties then. Do you have anything else to comment on before we?
I think that we can agree that we'll have any affirmative testimony, any affirmative pre-file testimony at the time that our legal brief is due. I think we've agreed that if we need an extension to get some of that, we can agree and stipulate between the parties and file that with the board. So I think that should work.
Okay. Any need for any further board discussion or discussion from any other parties? Seems like we've got that BlackRock. Any other comment from you on that?
No.
Okay. Then, I think our remaining issue is dealing with this intervention petition, but I think we probably need a motion from the board for the drafting of a scheduling order. And let me just run through what we would have for a scheduling order. This would have a hearing date of May 10th at 9 a.m. in this room, with the 11th reserved if necessary for the hearing. A deliberation hearing scheduled to begin at 1 p.m. on the 11th, with the understanding that if the hearing is running late, we might have to start late on that. A public witness hearing, 5 p.m. on May 2nd, location to be issued later. It's at some later point, but we would set the time for that. An intervention deadline of April 4th. An initial deadline for comments, legal briefing, and any affirmative testimony filed by Rocky Mountain Power by April 8th. The same for all other parties by April 22nd. And then replies by Rocky Mountain Power on May 2nd, with a motion deadline of May 5th. Oh, I forgot to ask about discovery turnaround time. Do we need a time frame in the scheduling order for how quickly discovery requests will be responded to?
Well, I would think that even if we had discovery at the time, and I guess from your standpoint, it's going to be a little bit different, because any discovery requests you have, you're going to need back as soon as possible.
Yeah, I don't anticipate a lot of discovery, but as has been stated on the other side, if we were to get on the 22nd something surprise, and I'll just let the board know that at the county level, when this permit at issue was addressed, there was not, for instance, the need was not, that was not contested, okay, the fact of need. It was really a location thing. So I don't anticipate that there's going to be a lot of discovery on that. But if the parties were to say all of a sudden, hey, we don't think you need this, then of course we're going to need to immediately kind of find out what's going on. It may be a lot of it addressed in the pre-filed testimony. I guess I'm inclined to say a 5-day turnaround, just to have something there. But just candidly, I don't anticipate either on our side or their side, and I could be surprised that there's going to be a lot of discovery in this. But
I don't anticipate a lot of discovery either. If we wanted to say, 5 business days turnaround, I think that could work. And then again, I think we'd be more than willing to make a phone call and say, hey, can I have 7 business days on this
Sure.
instead? I think that would be something that we could definitely work out.
Okay. Well, I would entertain a motion for all those dates I listed with a 5 business day discovery turnaround time. If anyone on the board is inclined to so move.
So moved.
Second?
Okay, any opposed? Okay, that's unanimous, so we'll direct a drafting of a scheduling order to that effect. And I think that leaves us with the final issue of the intervention petition from BlackRock. So why don't I go to Mr. Reutzel? Is that-
Reitzel, yeah.
Reitzel. I think I laid out the 2 options I think this board has for how to procedurally deal with your motion. Why don't we go to you? Just speak to your thoughts on this.
I don't want to make the board reconvene to decide the issue. I would, however, like to provide a written response to Rocky Mountain's opposition to our petition to intervene. I don't know if we could hold, I guess I don't understand whether or not we have to have another hearing just for you to issue a ruling. on that petition to intervene. Is that what you're telling me?
I think we would, and I think it, again, three of the board members are employees that work in this building every day. The other two could participate telephonically or certainly could come in person if they wanted to. But I think that's the way we've got to have a board meeting to make a decision on the contested intervention. And so you'd like an opportunity for a written response to the utilities objection.
I would, and I could have that.
Do you have a sense for when you think you'd want to file that by?
I could have that in by Friday.
This Friday?
Yeah.
Okay, so that is the 1st?
Yeah, I believe so.
No, wait, today's the 20, oh, you mean 2 days from today?
Yeah, 2 days from now.
Oh, the 25th? Okay.
Yeah.
Well, let me go to the board then. That would be the final response on that intervention motion. Should we reconvene as a board again with potential for telephonic participation sometime after the 25th? So, next week, the 28th through the 1st, to deal with this issue. And would parties have an interest in any additional verbal presentations, or at that point, are we going to just we'll have the parties' positions in front of us, and if we're reconvening, it probably makes sense to have the option for verbal presentations or questions if necessary. Any objection to that?
No.
Yeah, that'd be our preference as well. Again, we may not need to, but having not seen it, we'd like the option of addressing it. We're also, and I don't know if the board is considering this, the company is also comfortable if, for instance, if Wasatch County doesn't want to drive back down for that. I mean, I'm comfortable if any of the parties want to participate telephonically. The board, it's up to the board, but just for the record, if that makes it easier for such a thing, the company doesn't insist, for instance, that they show up to make their argument if they want to say something. We're fine if they want to do that by telephone, if that helps.
Okay. At this point, I don't know, Wasatch County hasn't weighed in on the intervention motion. Does that?
We don't anticipate weighing in on the intervention motion. So
Okay,
if
so
we
if you
could
wanted
appear
to
by
participate
phone.
by phone, that would certainly be appropriate.
Just so I'm clear, Chair LeVar, are you suggesting a meeting the week of the 28th? Is that and I only ask that because I will actually be.
Oh, I had not noticed. You're out of.
Yeah, but I
you're out of
mean,
the office that week.
I mean, certainly if you have a quorum, to deliberate on that or, publicly is fine with that. I just wanted to kind of note that I may or may not be able to get on a call, but I certainly will not be available to meet in person during that time, but I don't want to.
And in terms of dealing with this intervention motion, we really can't push it out too much farther since discovery and filing of comments is going to be moving forward. And you don't know if you'd even be available for a telephonic meeting during that week, right?
Yeah, I don't. I mean, I would certainly endeavor to try to make it, but I'll just disclose I'll be out of the country, so I'm not sure what the availability will be, but I certainly would make an effort to do so.
If it helps the parties, and I certainly will invite BlackRock to address this, if it helps the board, we have this other deadline. If the board wanted to defer ruling on this, see if anyone else moves to intervene, and then just schedule one time to address those sometime the week of between April 4th and April 8th, then you may solve the problem of one board member being gone and potentially, I don't think you will, but potentially avoid having to do this 2 times. But I recognize in saying that BlackRock may feel like, well, if we're not going to be in, I don't want to be spending time doing this. I'd like to know sooner rather than later, so they probably ought to speak to that. But I'm just saying we won't object if that's what's better for the board.
I'll note, Ms. Holbrook had indicated unavailability the week of the 4th through the 8th. Is that correct?
That's correct. I'll be
Okay.
in St. George for the conference. If we could schedule something, I would have to know fairly quickly so that I
A
can.
specific time.
A specific time and date.
To be on the telephone.
Correct.
Okay. And so since we have an intervention deadline of April 4th, we could schedule a meeting to address all intervention issues within a couple of days after that deadline. Is that soon enough? That's still, before the initial comments and testimony filed by Rocky Mountain Power, so anybody would know if they've been granted intervention before that, and then the next deadline comes a couple weeks later. So we're looking at maybe the Wednesday the 6th. For a board, again, does that work for you if you were participating telephonically from your conference?
The 6th should work. The only challenge would be after 4:30 PM. I would not be available after that.
After 4:30?
Mhm.
When I'm just noticing something on our calendar that I didn't realize, I don't have all the details on, I should have grabbed this. There's a 10 a.m. meeting here involving Questar that I'm not sure, I didn't bring my electronic calendar. Do you have your phone to see what it is?
What date is this, Chair?
Wednesday the 6th. Or maybe we should just look to the 5th. If we have intervention petitions by the 4th, is there any reason not to just do it the next day?
Well, I think Mr. Reitzel's got something on his mind.
I'm sorry, okay.
Yeah.
Share with us.
We would like all the time that we can get to prepare, especially in light of having to pre-file our testimony. And I think if we're waiting until April to decide whether or not we need to retain experts or who we're going to talk with, that makes it difficult for us. We'd rather have a decision sooner than later on that.
Okay, well, that probably puts us back to the previous week then, and we would, to accommodate that request, I think we could certainly have a quorum, but might be missing one member if you're not able to participate by telephone.
I mean, it sounds like it sounds like our only path forward, so, do we have a time, or I'm just wondering,
Well, it seems like maybe we could look at Tuesday, the 29th, March 29th then, for a meeting to deliberate on the intervention motion.
Yeah, that's fine with us.
would it be possible at all to, the 28th, is that an option at all?
Certainly.
Because I think I would actually still be able to get on a call on that day, if it was early enough in the day.
Okay, so that's this coming Monday, 9 a.m., is that what you're proposing?
Yeah,
9 a.m. on Monday the
I'm
28th?
seeing Mr. Mosca, and he's not sure if he's at his call.
I'm sorry this is turning into such a scheduling issue for the board. So is this, the parties would be addressing this, I take it, at that time?
Well, yeah, we would have received
Right.
BlackRock's written reply on the 5th, and then I think party participation probably depends on if there's board questions for the parties as we're discussing the issue.
So I will be traveling on the 28th, and like I said, even if I did it telephonically, I wonder if I could, wonder if Richard, well, if the board would, I mean, if nothing else, I could try and do a telephonic thing as well. I mean, I'm happy to do whatever, I don't know, but for part of the day, I'll be in traveling, but let's just schedule what the board can schedule. I think having Mr. White available is more important because I'm more fungible and we can get another me to show up, but it's, you can't get another Mr. White. So my suggestion is schedule it when Mr. White can phone in, and if I can't, someone else will.
Is there a time of the day, Mr. Mosca, which is more convenient on the 28th?
28th, which is this coming Monday.
Let's see here, so I'm just trying to think. Early, it would be still by phone, but earlier, I'd be doing it by telephone, but.
That's fine, yeah, I can do it as early.
But if I'm going to be doing it by phone, my client, I mean, my poor client's sitting here getting nervous. They may be sending someone else anyway. So do it the time that works for you, because we'll probably just send someone else.
Well, is there any reason to consider earlier than 9 a.m.?
I would just set the time that works for the board, and we'll figure out what to do for me.
Okay, so we'll look at 9 a.m. this coming Monday then? We'll get a response from BlackRock by this Friday, and then we'll schedule a hearing for 9 a.m. Monday morning.
And can we just, if we're getting their response literally on Friday, and then we're 9 a.m. Monday hearing it, could we maybe get that by, say, noon on Friday, just so that the company would have a few business hours to look at it before we're expected to address it? Did that work?
We have no problem with that.
Okay.
Thank you.
I think that completes our business for this hearing then. Any party have any other business that needs to come before us before we move forward and issue a scheduling order?
Nothing from Wasatch County.
Anything else from any board? Oh, well,
No, and nothing else.
from Black Rock?
No.
From any board members?
Here, thank you.
Okay, we're adjourned. Thanks.
Thank you.